Hello and welcome to this conversation on the rule of law. I know that this pandemic has meant many firsts, and a recorded interview as part of your course curriculum is another one of them. So I'm Tarunabh Khaitan. I'm a professor at the Melbourne Law School, currently stuck in London. And joining me is Dr. Dinesha Samararatne, a fellow at Melbourne Law School and a senior lecturer at the University of Colombo in Sri Lanka. Thank you very much, Dinesha, for joining this conversation. And between us, we are going to discuss today Professor Joseph Raz's relatively recent article called The Law's Own Virtue. It was published in the Oxford Journal of Legal Studies in 2019, so only last year, where he's revisited some of his earlier views on the concept of the rule of law and why it may be important. So that is the discussion. We will aim to wrap it up in only 20 minutes because we know that you're already doing a lot of screen time and we don't want to add too much to that. So we're going to begin.
Yes.
Dinesha, do you want to?
Yes, thank you, Tarun, for inviting me to have this conversation with you. So I thought we'll get into the heart of the matter. So this article is about the rule of law, and I know you want to sort of flesh out the concept of the rule of law in light of Raz's most recent intervention. Can you tell us very quickly, what do you understand by the rule of law? What are its principles, and what are the different ways in which we could understand this concept?
Thank you very much, Dinesha. So look, the rule of law has been a debated concept for a very long time in the legal literature. And very broadly, there are two camps. There's one camp which we can call the minimalist camp, or people who believe the rule of law is a relatively thin concept. And for this camp, so Professor Raz clearly belongs to this first camp, which tries to imagine the principle of the rule of law as a relatively thin principle. And for this camp, what the rule of law requires is that, well, first, that the government is, that the state governs by law and not by sort of arbitrary individual decrees of the ruler, whatever, and that the laws are reasonably clear, that they're reasonably stable, that they are publicly available for anybody to see what the law is, that they are general rules and standards. So they're not designed for particular individuals or particular groups. They're general laws. They applied prospectively rather than retrospectively. And there are a few principles that concern law. So these are all the law-making principles, the first 5 principles, what the law should look like. And then there are about 3 or 4 principles about law application, which basically speak to policing, prosecution, the entire law application machinery and the judiciary. And they require that the law should be applied fairly, that the law should be applied impartially, that the law should be applied as it is, right? So interpreted reasonably without fear of favor, without distortion, with what one can reasonably expect the law to demand. That's exactly how. So honest application is the other side of the rule of law. And so these are the thin principles that there's broad agreement on. Everybody agrees that these principles are part of the rule of law. Nobody denies that. The second camp, which is the maximalist camp, we can call it the maximalist camp, which disagrees with the minimalist camp, not on these principles. They also accept these principles. But the second camp claims, and Lord Bingham, with whom Joseph Raz engages in this article, as you've seen, is one of those people in the maximalist camp. They believe that the rule of law requires these things, but it also requires other things, including, in particular, an adherence to human rights. The law must respect human rights, fundamental human rights, must respect international law. It should be good law, substantively just law, things like that, right? So that is the main divide in the literature.
Yeah. Thank you, Tarun. Now, this is very important, I think, because there are 2 things that I could take away from what you just said. One is the significance of Raz's early intervention, because when we talk about the rule of law today, we take that minimalist description as a given. everybody agrees on it, and it's become part of how we understand the rule of law. Your second point about the difference between the minimalist camp and the maximalist camp is a very important one, because very often we conflate the two. Now, can you tell us in this particular piece how Raz responds to this conflation and the way in which we ought to sort of separate them out and think about the rule of law?
Yeah, so Tanisha, his main defense of the minimalist position is this: Raz is not someone who dislikes human rights or compliance with international law, whatever, right? So he says they are also obviously good things, and they are also obviously virtues that the law must have. The law must comply with human rights. His problem is a conceptual one, not a normative one, right? And by that, what I mean is that he thinks that we have to think of law's virtues, or the virtues that the law must have, as a plural set rather than a singular set, right? So think an analogy would be with a human being, right? A person can be a thief and kind at the same time, right? So you can be a Robin Hood of sorts. You can be a murderer who never lies, right? So we understand that human virtues are plural, and that a person can have certain virtues and not others. A person can be generous but lack courage. So we understand that human virtues are plural, and Raz's point is that so are law's virtues, that laws, um, uh, a legal system can be good in one sense, that it complies with the human rights law, and bad in another sense, right? That it perhaps makes laws retrospectively and therefore breaches the rule of law. So he says it just is conceptually clear, and it helps us focus our criticism of the law better if, instead of just saying the law is bad, because that is what it will become, right? If everything that makes law good is part of the rule of law, then saying that the law breaches the rule of law is simply the same thing as saying the law is bad. Whereas our criticism will be more focused and more biting if we can pinpoint what it is that is bad about the law. That is why he wants us to keep these different measures, different standards of testing the law separate. And I'm quite
So what do you think? Yeah, so that was going to be my next question, whether you find this argument persuasive, and if so, why?
Yeah, no, I'm persuaded for the same reason, which is I do think that that it's important for consensus clarity that we keep these ideas distinct rather than conflating them.
Yeah. So that is the main takeaway I got from this piece as well, because particularly working in contexts like Sri Lanka, we conflate these expectations from the law, and then as a result, find it difficult to react in more meaningful ways to developments on the ground. Whereas this distinction is, I think, very useful.
And that's not surprising. Can I just add a comment to what you just said, which is, when an idea becomes a slogan, right? When it becomes popular, then it understandably faces expansionist pressures, right? So if democracy is the only show in town, then everybody's hobby horse is sought to be put into that box of democracy. So rule of law is a very successful slogan, right? Every country wants to be known as compliant of rule of law. And therefore, politically, it makes complete sense for many people, for strategic reasons, to want to add, other good things into that basket, other good things that are by themselves more controversial, right? But it does lead to conceptual problems.
Yes, so that brings me to the other question that I wanted to ask you about the normative foundations of the rule of law. If this is the argument that Raz is making, and then he's also building on his earlier argument in doing this, what do the normative foundations of the rule of law look like today?
So this particular paper is actually a development of his earlier ideas on the rule of law that he has published previously. And he starts with with his old idea. So his first idea was, why should we care about the rule of law? And the first idea was we should care about the rule of law because it it allows us to plan our lives better. If the law is stable, if the law is clear, if the law is public, if the law is prospective, and if it is applied honestly and fairly and impartially by an independent law application machinery, then I will know when the taxman will come knocking and what I should do and what I should not do. And the law will never demand of me what is impossible, which is, retrospective laws are impossible to comply with. And I can plan my life around it, right? And that is one good thing about the law, right? Even when there may be other bad things about it, right? Now, that was his original defense of the rule of law. In this paper, he says that's a good start, but it still leaves many things unaddressed. It does not tell us how much rule of law should we have, or it does not tell us how stable should the law be, because the best way to plan my life is if the law never changes, right? If the law is always stable, your 10 commandments idea, you have 10 simple rules or whatever, which are all, but that is not how a state can function. So that old idea of planning your life, it's onto something, but he says it does not really capture or does not tell us enough that we need to know to make a meaningful assessment of the rule of law. His second stab is the rule of law is against arbitrary government, right? That it's against arbitrariness. But he finds that unsatisfying. Why? Because arbitrariness, if we think about the literature, arbitrariness is again another one of those slogans in which we have put in so many other things. But what it conceptually means is a decision that is indifferent to the reasons that apply to it. That's arbitrary action, right? But Razs says that rule of law is violated not just by arbitrary action, which is action that is indifferent to reasons. Rule of law is also breached when you make a decision on the wrong reasons, right? So when the state, when a judge or a police officer or a prosecutor, or even less, makes a decision based not on the right reasons, which is what is it the law demands, but wrong reasons, right? Which is, oh, will I be enriched? Have I been bribed to decide this way? Or even, will this benefit my party, right? Is the defendant an opponent of my party, right? Now, these are bad reasons. These are not arbitrary decisions, right? They're based on reasons. They're just wrong reasons. And the rule of law is also hostile, not just to indifference to reasons, but also to bad reasons. And Razs says, which is why arbitrariness does not fully capture the rule of law either. And then he comes to his most developed, considered view of the rule of law. So, rule of law assumes that the purpose, or at least the most important purpose of the state, is to act in the interest of the governed. And he says that, so this is his custodianship or trusteeship idea of the state, right? That the state is the custodian of all those who are governed by it. It has special duties towards them. And that is the purpose of a government. It says that in order for the government to do so meaningfully, it has to express a manifest intention of governing in their interest by open, prospective, stable, and general and public laws honestly applied. So what he sees the rule of law as is the tool and the only tool that is viable if we accept the idea of custodianship. So that is his most considered view, that if the state is to work for the interest of the governed, then we have to have rule of law. And now you can see why it makes sense, right? Indifference to reasons breaches the idea of custodianship, because a custodian should not be indifferent to the reasons. But also acting on bad reasons, self-enrichment, is bad because you're not acting as a custodian if you're acting in your own interest or your party's own interest, right? So it captures all these worries about the rule of law. It's also an improvement on the planning idea, because a government acts in your best interest generally by allowing you to plan your lives, but sometimes it is right to change the law. Sometimes it's even right to act retrospectively for the interest of the governed, right? So it manages the difficulties with the previous two ideas well.
This is very interesting for me because, as I mentioned to you before we started this interview, this argument reminds me very much about the notions of custodianship and stewardship, which is being talked about in historical traditions in the South Asian part of the world, which interestingly has also been incorporated by the judiciary in some case law in Sri Lanka, where we talk about the state being a custodian and a steward.
The Canadians are very big on this idea as well.
Yeah. So that takes me to the other point that struck me about this piece, and that's the claim to universality. Could you speak to or respond to this claim he makes about the rule of law being a universal principle, this particular explanation of the rule of law as being a universal principle?
Sure, Dinesha. So this is a very interesting point, and to the listeners, we will end on this point. So if you're getting jittery about how long this video is going to be, but Razs makes a very interesting and nuanced claim. He says the rule of law is a universal virtue wherever there is law, and not just state law, by the way. Says even associations that are governed by law. You know, Dinesh and I are on the editorial board of the Indian Law Review. We are governed by rules and laws, right? So it's a virtue for all law-bound institutions and organizations. It's a universal virtue, but it is manifested in a culturally specific manner. So what counts as stable, what counts as public, what counts as open, what counts as not. So these things are determined by local conventions that are appropriate to the social organization that is being governed by the law. So the norms of publicness, for example, that apply to Australia as a state will be very different from the norms of publicness that apply to the Indian Law Review, right? And likewise. So this is that local conventions give content to how the rule of law is applied in particular contexts, and that is culturally inflected. But the fundamental idea and its fundamental justification are universal.
So that's the challenge for lawyers then, to understand how this universal idea can be made manifest in a given context, isn't it?
Exactly, and that's an important point, Danisha, because not all local customs, just because it's local does not mean it abides by the rule of law, right? So some local customs do, others do not, and that is the biggest challenge. But I think we're out of time for this interview, so we will stop here. Thank you very much, Dinesha, for talking to me about this very interesting paper, and I hope that you guys have a good discussion on the rule of law and on Professor Raz's view about it. Thank you very much. Bye-bye.